case we have covered. Now we have to start from the fictional theory. So realist theory we have covered, and we have referred as to how that particular theory do not confers to the existing rules of international law. State alone cannot be the sole and only subjects of international law, and there cannot be this particular observation that merely the objects, uh, state being the subject, and rest everyone else is an object, right? Because we have reference of international organizations also emerging, and in that case reparation case establishes the fact that other than state do also have this opportunity, do also have this right that they can enforce it, provided this is available within the mechanisms of international legal system. And in that case, it was found that due to the reference of the Charter of United Nations itself, and then there is a very important immunity, convention as well, which is with respect to international organization. 1946 and 1947, immunities to the office bearers who are working for United Nations, and then the immunities with respect to United Nations as well. 46 and 47, those particular references of those conventions were also borrowed. Plus, it was also seen that there are certain responsibilities, corresponding responsibilities, which both the member states as well as non-member states on one side, vis-a-vis the United Nations as an organization, requires to be fulfilled. And this can only be done when there is mutual respect for each other's responsibilities, right? So that case, questioned the very basis on which realist theory was formed, that states are the subject, rest other entities are the objects of international law. They are incumbent upon state receiving any rights, duties, or obligation under the larger framework of international legal system. Now, the next theory is fictional theory, right? And this is also, and this is something which I, if you can recollect from the earlier lecture, I said that appears to be more theoretically sound. This is something which was propounded by Kelsen, right? And but the practical aspect of this theory is again something where the theory does not makes any sense, ultimately leading us to the functional theory, right? Which is basically nothing but accepting that there are new emerging subjects of international law acknowledged under the realm of international law altogether, which includes even individuals, right? This was something which was never been conceived as a concept in the early part of the development of international law, particularly in the 19th century. But 20th century onwards, you will find out that there were some reflections or some references of bringing a case for individuals as well, not just about states or international organizations or non-governmental organization or non-state actors. Individuals were also gaining importance. In fact, there is a very important judgment of 2009 International Court of Arbitration, which is Sudan, related to that particular. I might not be recollecting the exact citation for that particular case, but therein, an entity of state against an individual claim was accepted, right? So that much of an importance individuals have been gaining, and classical reference of individuals references found in with respect to your these human rights, like conventions, or for that matter, many other conventions, right? Humanitarian laws, international criminal law, particularly with the establishment of international criminal court, right? A person who is involved with any of the prohibited offenses that has been listed under the Rome Statute can be tried by a non-biased, apolitical international institution, right? This is what, but there are certain, if you read further with respect to the manner in which Rome Statute has been developing over the years, it is, there are some apprehensions also raised by few states, largely the third world countries, alleging that global West targets their, like heads, or it is particularly like bringing justice with respect to the kind of like offenses that has been largely been played on third world in the third world countries. What about similar kind of activities done in the Western world, right, the developed world, and what about their responsibilities and answerability? The result is few states have already submitted their application with respect to like bring coming out from that particular statute, right? So it's a kind of thing which will take place, right? And then the movement of various scholars arguing that it should not be limited to those particular crimes alone. There should be listing of few more crimes, right? And there is a debate with respect to that as well, right? That how much of interference does international law can have on matters but which are exclusively within the domains of state all alone. And this was conceived to be exclusively within the domains of state all alone. Vis-a-vis the other argument which says that international law largely moves towards bringing peace and balance within the society, with the arguments of human rights emerging, humanitarian law emerging. It says that the states must do away with that particular notion of complete sovereignty. It has largely been affected because of the advancements that has taken place under international economic law and all those kind of arguments. So there's a debate, right? If you ask, like there are two sets. Traditional scholars of international law, they believe that there should be limited, like role of international law in domestic matters. There is another belief which suggests that the world has shrunk to an extent that countries have to live together, and in that process whatever rules are developing, those must be appreciated. And they believe that international criminal law, particularly with the establishment of Rome Statute, ICC, is an is a progressive step, and that's part of progressive development of international law as well, right? In fact, your space laws, right, your air laws, right, those are all parts of progressive development of international law, right? And credit must be given to the institutions which have been playing significant role with respect to this. In fact, with respect to this, because I was reflecting on this particular aspect of progressive development of international law when we were discussing about codification of international law, right? One of the area which is still with various states not been clarified is the jurisdiction from where the outer space, like the realm or jurisdiction of outer space starts and where the realm of air laws ends. This is something which is not yet have been clarified. There had been efforts on behalf of United Nations, various scientific measures, which has concluded recently. They have concluded that it is not scientifically clear enough to come to clear terms as to the jurisdiction of both of these two, right? Largely, and then the notion between the two realm of international law, the emerging realms of international law, that air law is a complete is something which provides and grants complete sovereignty to the state, right? And then outer space is something which is available for world altogether, right? That's the idea. Because with respect to air law, if like which largely developed alongside your law of sea conventions, that the land and the territorial waters, 12 nautical mile territorial waters, whatever is the like anything which is above that is part of exclusive sovereignty of a state altogether, right? And necessary measures in the form of conventions, bilateral treaties, certain customary practices have developed or are developing in that particular notion altogether. Now, with respect to outer space, there are number of United Nations General Assembly resolution which started from 1958, continued till I think 1962, if I'm not wrong enough, because then came the Outer Space Treaty 63 onwards, right? There was prohibition on use of nuclear weapons testing first, and then Outer Space Treaty, right? So it has been largely been made clear to the world altogether that whatever is in the outer space, that's for world to and it is not within the jurisdiction of you alone, because and it is for world to explore, right? So these two aspects. So that's part of progressive development of international law, because there are various methods that are ongoing to determine this, and in fact there are various theories also emerging. If you have interest with respect to space law, you will find out air and space laws. You will find out that there are multiple theories which have been emerging. One of the theory which is propounded by United Nations itself, that whatever is like in the outer space, that's for world to explore altogether. It's a common like heritage of everyone, much like the high seas, right? Similar to the concept of law of sea, and we will discuss more on that particular aspect in detail, right? Because that demarcation was must for world to realize, right? When law of sea was convention was concluded, the final one, the third law of sea convention, not the first and second, right? The third law of sea, which is of 1982, which ultimately came in force in 1994, right? And that law of sea is largely been credited because it, for the first time, demarcated the jurisdiction. So 12 nautical miles, absolute sovereignty on those territorial waters, extended sovereignty for like further extension on the basis of contiguous zone, then extended benefit of like exploring resources in the form of EEZ, exclusive economic zones, then high seas, right? And within high seas also there were certain rights which have been granted to coastal states. So, but the high seas domain is covered within the realm of world altogether. This is not something for which any state can claim their control over, right? It's for world. So any resources lying underneath at the same point of a time also acknowledges the continental shelf, the extended part of territory which is beneath oceans, and to what extent that particular uh, right of a particular state like continues there afterwards, continues to. There are few people in the lobby, beta. So that's a topic which we altogether left. So we'll come back to this fictional theory. Realist theory, states alone. Fictional theory says that individuals being are also your subjects of international law, right? Now it says that according to fictional theory, individuals are the ultimate subject of international law. State is basically an abstract concept, right? And it is no more than an aggregate of individuals who compose it. Now, if you can relate it with respect to jurisprudence that was emerging at that point of a time, when fictional theory was developed, properly developed, the notion of fictional theory rests upon the concept of social contract, right? Many scholars came, like Rousseau, like all those scholars who were arguing on this particular line. Hobbes, for that matter, started from Hobbes, right, with his work of Leviathan, right, which came just after the work of Hugo Grotius, right, and both of these two scholars are quite relevant because under the like if you have studied more in detail the ancient like development of international law, there was one school which believes in like Grotius amongst the natural law scholars, right, and there was another school of natural law school which were tilted towards Hobbes, right. So one school which was arguing similar to the work of what is being propounded by Grotius, and the naturalists among themselves believed that Grotius was more of a naturalist than the Hobbes, right? But Hobbes brought out a very important concept of social contract. He says that the world is all chaotic, right? There is no settled rules, and unless and until a group of people join together and claim for certain rights, those needs to be preserved, protected. Customs in the form of customs, in the form of treaties, social contract. So now this says this particular theory is more nearer to the idea which was raised by Hobbes altogether, which says that state being an abstract concept is no more than an aggregate of individuals who compose it, right? So therefore, the policies which are made in the international plane are ultimate regulation and control of individual conduct all alone. So this is where fictional theory comes into picture. They say that whatever policies you have been bringing under international law, the ultimate like beneficiary of those particular policies or ultimate like person who are like regulated through those particular policies are individuals. So therefore, individuals should be treated as the primary subjects of international law rather than being granting this particular status to a state, which is merely an abstract form of the individual will altogether. Right? Social contract theory is a very relevant theory. In fact, whichever state has constitution, it functions on that particular basis of social contract itself, right? Will of the people. India has a constitution, which grants each individual sovereignty, collective sovereignty, right? Which they have like submitted in the form of a constitution, through which they select their representative with a mandate that their interest will be taken care of, right? So, so it's a very interesting concept altogether. Those who have studied constitution will relate it more closely. The concept of social contract, right? And that's a very interesting aspect. Social contract and its emergence, and then the idea of historical law school. Because if analytical law school was questioned and they were not able to answer those particular questions, and in their peak were the questions that were raised by scholars of historical law school, Savigny, Henry Maine, right? So all of these scholars, they raised pertinent questions against the scholars of analytical law school. And from there onwards, at one point of a time in 18th century and 19th century, early part of 19th century, there was a belief that analytical school is going to be like the ultimate school of jurisprudence altogether. But historical law school, like questioned that particular notion altogether and dearly, like affected the common notion. Later on, we had the revival of natural law school, right, which is largely been credited to those particular world wars, right? And in fact, in my earlier lecture, I have referred to this particular aspect as well. Unlike the many scholars believe that the early part of 20th century did nothing but invested great part of like human engagement into the war and peacekeeping processes. There's a belief of certain scholars who say that this was a fertile part, like period of various emergence of theories. At least the notion that world has to come together, the consensus that ultimately resulted in the making of United Nations, an adoption of United Nations Charter, is because of those world wars, right? The world did not wasted anything; it learned a lot. The learning is something which helped the world there afterwards, right? Since 75 plus years, we had not witnessed the kind of war that the humanity has witnessed in the early part of 20th century, right? We are still being successful in managing, like some solutions to the kind of problem the world is facing. Of course, there are issues as well, right? If you look in this particular perspective from the side of a critic, he will say that like international law has done nothing, but it has, with through international organizations, created an atmosphere of surveillance. Now, like this is a very interesting aspect because they point their argument from the perspective of emergence of international economic law and the powerful role these international organizations have been like making, starting from the like the manner in which IMF has a very important role, right? It's a kind of a surveillance over the kind of policies a state has been adopting in terms of its economic matters. And they allege that it's a kind of surveillance. If state has not been following something which has been suggested by these powerful international organizations, they are facing certain kind of restrictions, right? Sanctions, indirect sanctions, not direct. So it's kind of a surveillance on the kind of policies a state has been adopting, undermining the very concept on which international law was developed, which is giving complete, like sovereignty for state to enter into this partnership of a collective world, right? Collective consensus, right? So that's a different argument. So coming back to this, Professor Kelsen, he was an ardent supporter of this particular theory, and he says that like legal rules of international law purely applies to people and they're within a defined territory, and therefore their importance must not be neglected in understanding international law. Particularly the concept of subjects of international law. Now, this theory regards that state is merely an abstract form or a fiction, which is based and based on that particular fiction, the rights and duties which are assigned to state are only rights and duties of the men and women who compose them. Therefore, it is ultimately the individuals who are the subjects of international law, right? So this particular view considered two laws differently. One, they said that international law must be viewed differently from state or domestic law, right? Though both of these particular law applies to individuals, and therefore both of these laws are individual centric. So even for state also, the subjects for a state are individual. Similarly, for international law, since those rights, obligations, duties are upon state, which is merely a fictional notion of individuals altogether, for them also it is individual. So individuals remain the primary and the sole source of international law, right? Now this is what I was referring to. Theoretically, logically, if someone looks into this particular theory, it appears to be more reasonable. However, there are certain you know, like tricks within international law, right? One of this has been referred in this particular case. So therein you will find out that state has reference, right? Even though it comprises of the will of a people or individuals altogether, but under international law, it is not merely the only requirement for that makes state the subjects of international law, right? There are issues of recognition, right? Those are not based on the individual preferences. The recognition is based on the kind of politics a state plays. Say, for example, in the recent times, right, we have been cautious enough of not granting any recognition to the government in the territory of in the state of Afghanistan, right? Majority of states have been also following similar kind of practice. And the moment you will grant certain recognition to them, either de jure or de facto, right? If you have been granting them de jure recognition, that means it's a recognition of one time. You cannot revoke it. There is no possibility for states to go back. Even for de facto recognition, also states are still cautious enough. This is what I will be using, the term cautious enough. And for that purpose, the government of Afghanistan have been approaching the world. They've been approaching various states, asking them to recognize their government because there are certain benefits that a government receives on its recognition. Now, when we will discuss more about this particular concept in Unit 3, you will find out that there are two forms of recognition altogether. Right? Why recognition is important, particularly with the change of government, right? Does it mean that in any state, wherever there is a change of a government, the government should approach the world altogether and say that please recognize us? No, it doesn't happen. It happens only on occasion of two. There are two sets. One is by constitutional means. If there is a change of a government through constitutional means, you will not require or seek recognition. A mere declaration of another state is proper enough. Say, for example, if there is a new government which is elected, what you'll see, you find out that the heads of other states, they congratulate the new government. So that particular mere acknowledgement is proper enough of conveying the fact that they have been recognizing this new government, right? Provided it has been made in the manner of constitutional means or something which is permissible under international law, right? Something that is permissible under international law. So because it's not that merely constitutional, because there are certain states which have been wherein you have empires as well, right? And therein also the government changes. So something which is permissible under international law, and more in detail we'll cover. Second issue is more important, where there is change of a government because of unconstitutional means, right? Or something which is prohibited by international law, right? And therein the recognition plays a very important role, right? So state takes a very important step in that particular regard. we had played a significant role. In fact, there was this uh, change of a government in 1980s, uh, and India was first of the countries to recognize such change, right? Which was with the help of a foreign state, right? There was a because of Vietnam and some other state, there was a change of government that took place in part of not recollecting the name of state. Second is, that's one of the incidents. Second incident is your change of the government in Bangladesh, right? After the war, we were the first, India were the first to recognize the government and the state, both. And for significant period of a time, we continued with our lobbying to recognize such a state because Bangladesh was not accepted ipso facto by world altogether, right? By merely with its declaration, world was a little bit hesitant in acknowledging the membership of this particular new entity altogether. So recognition will refer it in more in detail in Unit 3, but the point is state plays a very important role over there. So we cannot attribute that aspect of state with individuals all alone, right? And this is something which was also acknowledged in Mavromatis Palestine consensus case. It's a case of Permanent Court of International Justice, PCIJ, right? And there were series of cases, right? This is 1964, which continued for 3 years. It's a very interesting case, right? There was a mandate state, the territory which is now in a question, which is now state of Israel. It was a mandate state, and we will refer this particular aspect as well as later on, right? Because now there's no mandate state under international law. There is no protectorate state. There is no trusteeship states available. Remember, when United Nations was formed, there was an additional organ, Trusteeship Council as well. Now it doesn't have any role to play because all the trust states, they have either secured independence or they have been part of the other states, right? But there was a question, there was a concept wherein state can be protected on behalf of some other state, and that was continued. And there were mandate state as well under the scheme of PCIJ as well, like the League of Nations, there was this acceptance of mandate state. And therein this particular issue came, Mavromatis Palestine consensus case, right? Now, PCIJ observed that under international law, a state is entitled to protect its subject when injured by any act contrary to international law. Only state. Now, I am saying that in the recent years, particularly in 2009, where there was an arbitration proceeding that took place against the government of Sudan, individual role was also taken into consideration, an individual claim against a state. But this is of recent time. This is of 1929, right? Roughly some 90 years back. At that point of a time, the PCIJ says that for enforcement of certain rights of its subject means your individual, state reference is quite necessary. Unlike what has been propounded by fictional theory, which says that all the rights, duties, and obligations are with respect to individuals, not the state. State is merely a fictional entity to represent their collective will, right? So it is ultimately the individuals who are affected by international policies. It is ultimately the individuals who are affected by domestic policies. So individuals should be granted the primary role under international law. Fictional theory. But Mavromatis case is an counter to this, right? Now they said that measures like use of diplomatic channels, right, international judicial proceedings suggest that state is in reality one which asserts its own right, its right to ensure in the person of its subject respect for the rules of international law. So if there are certain obligations which will be enforced against a particular state, those are with respect to that state itself. Say, for example, the Tehran case, right? That is with respect to diplomatic immunities. We all know about that particular incident, a very famous incident that took place. And it's United Nations diplomatic immunities, like that particular case of 1980. Right, in Tehran case, what happened? There was reference to Article 22, Clause 2 of your, VCDR, Vienna Convention on Diplomatic Immunities Relations. Sorry. So that particular convention under Article 22 suggests particularly clause 2 of that particular like convention suggests that state, although not participating in any act which is prohibited directly, will nevertheless be held liable for not taking appropriate steps or measures. Right? And in that sense, the International Court of Justice held that the government of Iran was negligent in performing its proper duty. Right? So they were held liable because of the provision, Article 22, Clause 2. Right? So you have to take necessary steps to ensure that anything which is prohibited under the rules of convention does not take place. Merely bringing an evidence that the involvement of the government or the state was not there will not suffice. There is an additional requirement of bringing additional measures of protections, necessary steps, which was lacking on behalf of the government of, or the state of Iran, and that's why they were held liable. But diplomatic, relations, it's something which is very difficult to understand under the international law. It's not that easy. It's not part of our syllabus, but I will just give you a few reflections on this. There are largely three conventions, four conventions particularly. I might be recollecting only three as of now. There is another fourth convention of 1973, which provides a certain protection to internationally protected persons, including diplomats, right? But there are three: VCDR, VCCR, right, which is Vienna Convention on Counselors, and then special missions, right? All of these four conventions are quite relevant. This is with respect to state officials. There are multiple treaties, agreements, conventions, right, with respect to international organizations as well. Particularly, when we talk about international organizations, as of now, it is United Nations. So United Nations, for its officials and for certain missions, also has certain immunities granted. Those are referred in 1946 convention and 1947 convention, right? But there is a very interesting case in England, that is between Libya, I think, between Libya and England, right? An incident took place, St. Francis Times Square incident. That is basically what is being called, right? From a Libyan, consulate, a gun was fired, and that ultimately killed a policewoman who was who was actually taking care of those particular demonstrators, right? And with that particular gunshot, she died therein. There was a mechanism which was available for United Kingdom. They would have taken care of that particular mechanism, which is under the VCDR and its amended protocol. But they did not took that particular measure. Instead, there was a different practice that they followed, which is commonly a kind of a practice that world is witnessing. See, which is that they made diplomatic protest. What they did is they said that your diplomats need to move out as early as possible, and you need to leave. They severed all the diplomatic relations with the state of Libya, and they asked them to vacate that particular premise as well. And with their leaving from that particular territory, they entered that particular premise, right? And the argument for for UK was that they wanted to protect the concept, which is state's inviolability, right? That state has complete right, which they needs to be protected. So they followed that particular rule, which is merely a customary rule, not a customary rule, but a rule that has been followed merely by larger number of groups of state, not referred in black and white. It is not codified. Say, for example, India made a diplomatic protest in this recent Chinese, Winter Olympics inaugural function, right? We didn't send our diplomats over there. This is not something, a kind of a protest which is referred anywhere in any particular convention. It's kind of a practice, right? Largely being done, right, by world altogether, not codified. So there is a great part of providing, this particular concept of diplomatic immunity, which has been codified, but there is also, and this entire codification with respect to diplomatic, consular relations, special missions, right, of internationally protected persons is done by International Law Commission. So this is another example. Along with law of sea example that I've quoted you, this is another classical example. In fact, with respect to diplomatic law, there were customary practices, so it's not that difficult for International Law Commission to come into exact terms. And in VCDR, which is like diplomatic relations, that's the most widely ratified convention, having more than 180 like countries as its member, right, who have ratified that particular law. Unlike VCCR or special mission, you will have very limited number of countries ratifying that particular provision. But consular, special missions, and the third one, with respect to internationally protected persons, certain immunities, right, including diplomats, 1973, these are progressive development of international law. You will not find enough practices in the past with respect to the position of counselors, right, councils. But this is something which is being made on behalf of International Law Commission and actively refers to that particular part, Article 13, Clause 1, Subclause A, progressive development of international law and its codification. You will hardly find any particular customary rule with respect to protection of counselors. But International Law Commission take part of that particular process as well. When they were preparing for diplomatic relations, they found out that within the scheme of governmental officials, counselors also hold a very important role, so much so that their role is as equivalent to the role of diplomats, right, but slightly lesser to them. And since the world engagement was getting like more like there was lots of engagement with the world, and they found out that this particular mission should also be protected, the mission of counselors as well, because they are in direct negotiation in terms of sending of people, all those roles which they perform under Article 5 of VCCR. If you look, there's a role that has been performed by counselors referred, and it is found that their role is equally important, not as important, but equally important, right? And we had that particular instance as well, right? In parts of like USA, Cobra Garde incident, if you can recollect it, that there was this, because the point is there's two concepts through which diplomatic immunities are protected: ration personae and ration materiae, right? Ration personae means by the very fact of being office, like the position in which you have been, by the very position of yours, you will be receiving certain immunities. Ration materia means by the very kind of act that you are performing. So if you are a diplomat, you are a minister, you are a head of a state, you will be receiving certain immunities, complete immunities for that matter, because no one can have arrest you, no one can initiate your case, criminal case against you. There are certain limitations with respect to civil matters, but this is again similar, like similar to your customary practice, because never in the customary practices there was complete immunity granted to a diplomat in terms of its civil liability. So that is also been reflected in VCDR, right? Vienna Convention on Diplomatic Relations. But VCCR, there is, like, so diplomats complete immunity have been granted to them, but for counselors it is ration materiae, that is the acts. And if you look to the VCCR provisions, you will find out that they have been also granted this immunity of like this arrest, unless there is a grave offense. It's a very interesting provision, unless a grave offense has been committed. So if grave offense has been committed, then the counselor can be arrested, right? But the problem arises, what is grave offense has not been clarified, right? And therein the entire confusion arises with respect to the immunity, particularly with respect to counselors, right? Counselors' mission. So largely depends on the kind of interpretation a state has made within its own domestic courts. And in US, violations of labor rights is considered as a grave offense, right? So in India, that's a normal practice, right? If you look into that particular case, the facts of that case, it's a normal practice. But therein, like very nowadays, there is a change in their policies as well, but they largely respect their labor laws. In India, we hardly give any reference to these aspects, right? It doesn't matter for us that there's a class of workers who require special protection. It is outside the purview of state consideration, largely because of the capitalist policies that we have adopted. Labor's trade unions, which were at one point of a time significant contributors in terms of policies that state has been like incorporating. There was quite influential labor unions. There are still certain quite influential labor unions, but not to what they were at one point of a time. In 1980s, 60s, 70s, we'll find out that labor unions were quite influential. Many of those particular cases, which you can find in the Article 19 with respect to freedom clause, I consider Article 19 as a freedom clause, right? Similar to the provision that has been available under U.S. Constitution, but we have a very modified version of freedom clause, which is similar to the kind of argument that Roscoe Pound gives. Remember, if you can look into the working of Roscoe Pound, you will find out that similar, the kind of argument he's been presenting with respect to three balancing of three conflicting interest, right? And that's the final outcome of Article 19 altogether. And that's why Article 19 is quite difficult to take care of. Roscoe Pound gave postulates, right? 5 initially, and thereafterwards he added 3 more. And we all know there is a lot of criticism with respect to the manner in which Roscoe Pound gave his argument. But under sociological jurisprudence, there are certain questions against sociological scholars as well. But that's quite relevant. Balancing three conflicting interests: state interest, which is public interest, proper law is the law that balances these three conflicting interests: the individual's interest, public interest. Look at your Article 19, Clause 1 and appreciate our constitution on many counts, right? And this is where Roscoe Pound's argument came. It has been argued and have been formulated into the text of a very important piece that state represents the interest of people, and it is because of their existence, which is what has been made by the theorist, a fictional theorist, who says that the ultimate object of laws for state is individual, for international law is individual. So instead of claiming them as an object, they are primary subjects of international law altogether. Right. So there is a relevant paragraph for that particular matter, which is quite important. This is part of the judgment of Mavromatis case itself. Look at the judges as well. In this particular case, look at the judges who were involved, and you will find out few names which have got or we have learned in the earlier classes. Right now, he's one of the judge, and the judgment says not one of the judge, right? Because there is no specific judgment altogether that comes on, unlike in the Indian domestic system, wherein you will have different judgments. They have a unanimous judgment, right? So it says that it's elementary principle of international law that state is entitled to protect its subject when injured by acts contrary to international law committed by another state from whom they have been unable to obtain satisfaction through the ordinary channels. And what are ordinary channels? You have channels of approaching the relevant domestic courts. By taking up the case of one of the subjects and by resorting to diplomatic action or international judicial proceedings on their behalf, a state is in reality asserting its right to ensure in the person of its subject respect for rules of international law. This is what I've referred, right? So this entire paragraph is this one. So it is states' right that on behalf of its subject, they are ensuring that those rights are properly respected and they can be enforced. So it is not the individual, which is what is the claim of fictional theorist. It is other way around, which is what was made by realist school, right? But then within the realist school, you have the reparation case, right, which does looks to that particular theory of that state alone are the only subjects of international law. Reparation case brought out a new entity over there, which is international organizations. And international organizations are not something particularly United Nations, which is not something which is under the control of any particular state. This institution runs in parallel to the states. So much so that at one point of a time, it was argued that United Nations is a super nation altogether, right? Because it is bringing new resolutions, new conventions, it is bringing new declarations, it is bringing new decisions. Decisions are mandatorily to be followed by state, right? Security Council, particularly under Chapter 7, if it's coming up with resolution, that resolution is binding upon all the other states, including non-member states. So it is acting as a super nation. In the recent years, you can say that it is not as like as super as it was at one point of a time, because nowadays instead of United Nations, there are other agencies which have gained relevant importance, particularly WTO at one point of a time. Now in the recent times, WTO is also an institution which has lost its quite influence, right? But it is all because of the structural difficulty, deficiency. Once that has been corrected, because there was a very like I don't know what kind of a role US has played by not appointing there's a requirement of certain appointments, and USA did not appoint it for the purpose that it wants to limit the control of WTO, and this is done under the regime of Trump presidency. Like they wanted to undermine the role of WTO, and to a great extent, this has been done as well, right? But it will re-emerge. That's a structural deficiency. Once that has been corrected, you will find out that WTO will regain its lost ground. But IMF, they are still powerful. World Bank is still powerful, right? Comparatively to this United Nations, but the United Nations is also gaining importance through WTO, no WHO, right? Especially during this particular period of pandemic, how much of a lost ground they can recover, that's again a matter that needs to be understood and understood carefully in the recent years, right? Because there are lots of changes in the political sphere of world that has been taking place, right? So we'll just stop at this. I believe we are out of time as well now. Yeah. Chalo. Any doubt if you'll have, we can come across with those particular doubt. The remaining students, I will just mark